Okay, guys, we're just going to go ahead and continue from where we left off with the previous lecture. This is going to be continuing your tort or civil law notes. Now, what we're going to talk about today is we're going to talk about really the three big types of tort cases. Now, just so you're kind of aware, what we're going to cover today is going to be just number one. We'll have time to get through number two and number three later on, but for today, all we're going to get to cover is just intentional tort. Now, at first, I do want to give you just a very brief explanation for all three so we can dive into them deeper as we go forward. Now, first one, what intentional tort is just when a person knows and intended for physical consequences, or even if they weren't necessarily thinking about those consequences, they should have known that there are consequences to their actions. What this is really suggesting is this person intended to cause another individual or group harm. Now, when we talk about civil law, that harm can really range to a bunch of different levels. It can be just causing financial difficulties. So I use this example, this picture on the very top here. What this was actually a story of an incident of road rage that took place a few years ago, where this individual is going to be driving the car that's behind him, but in front of this other car. He pulls out a tire iron and is going to hit this other car in the headlight, and then he's also going to hit the other headlight. Now, from this, you can see that, yes, this is going to be damage to property, but the person who took this video is going to also sue for mental damages as well, for pain and suffering. So there are two real types of intentional tort cases. The first one, we're going to talk about what's going to be injury to person, and we're also going to talk about what's injury to property. Now, I use this example on the top here because, yes, there is going to be injury to property in that it's going to cost money to repair the headlights that this individual broke. So you can sue for the repair of those headlights. But there's also going to be injury to person involved in this as well. Now, if I remember correctly, I believe this person is going to sue for mental distress. If I recall right, I believe that lawsuit's actually going to be way more than the property damage that was caused. So we're eventually going to talk about the difference between injury to person and injury to property. Now, like I say, I do want to give you just the other two types of tort cases now, but we're going to get into the specifics of these a little bit later on. So the next one that we are going to talk about is going to be neglect or negligence. Now, what this kind of tort case is referring to is that an individual or a group or a company is going to have a certain level of responsibility, that it's their job to do something and that they did not perform the way that they should have. It creates a situation of unreasonable risk or harm. Now, I always just kind of use an example of this where if you are responsible for someone else, where if you are, for example, in charge of a child, a toddler, a baby, and if you're doing something else when that toddler or that baby gets injured, you are negligent. That it's your fault because you were supposed to be in charge of watching that child. So if you have some kind of situation where you might be babysitting and that child gets hurt while you were in charge, that's your responsibility. You were negligent. Now, we're going to get more into the specifics of this as we go forward, but I do want you just to understand the real basics of it. Now, the third kind is strict liability. Now, you're going to see this again because we've talked about strict liability cases in regards to criminal law. There's also strict liability in regards to civil law as well. What strict liability is you're engaged in activity that's simply so dangerous that there is a real serious and evident risk of harm to individuals. Now, I always kind of use this example because the court uses this example too, where if you are demolishing a building, if your construction company is in charge of that, demolishing a building is so dangerous that contractors are just automatically responsible if a passerby is injured. Now, again, we're going to talk more about this going forward, but I also use this other example of owning a dangerous animal like a dog with a bite history. can be considered strict liability, in that that animal is so dangerous that just simply having them as a dog can be, in fact, where the owner is responsible for anything that dog does. Now, again, we're going to talk more specifics going forward, but I do just want to give you the basics of these today. So today, what we're going to be talking about is going to be A. We're going to be talking about intentional tort, and for today, we're just going to be talking about injury to person. We're going to talk about injury to property a little bit later on, but for today, we're just going to talk about injury to person. Now, before I get too far into this, I do just want to give you some classic examples. Now, the first one that we're going to talk about is going to be assault. Now, again, we've talked about assault as being a criminal charge, but it can also be used as a civil or tort charge as well. Now, in referring to assault, I do just want to remind you, assault can be threats. It can be a show of force, even a movement of an individual or even a group or corporation that's going to cause fear in another. Now, assault can take a lot of different forms, but really the barrier between assault and battery is going to be the contact. It's going to be actual physical touching. Now, we're going to talk more about battery in just a moment, but I usually kind of use this little example. If we were in class, I would show this little example where I take a piece of paper, crumple it up, and throw it at someone. If it does not hit someone, it can still be considered assault. It's a show of force. It's a threat. But if I take that piece of paper, crumple it up, and it does hit someone, it can be considered battery. Because in this particular instance, battery is just any uncontested physical contact. Now, I always use this little example of the crumpled up piece of paper because if I throw it at someone and it does hit them, it can be considered assault and battery. Of course, if you're kind of looking at it just as a normal citizen, though, no one would ever really bring a court case based on a piece of paper. This is going to be really the dividing line as to what is harmful contact. If you feel harmed by a piece of paper hitting you, you could try to bring a suit, but most likely any judge, any court would just throw it out because there is kind of an underlying reasoning behind this. Really, the test as to is this considered assault and battery is, would an average person consider to be offended by that action? Now, a crumpled up piece of paper, most average people would say, no, that's not battery, that's not even assault. But if I use this picture on the right side here, actually threaten to punch or actually contacting someone with a punch, that is assault and battery. That is going to be something where you can be sued over it. Now, we've sort of talked about this previously where the idea of civil law is to just make that person whole again. So if there is someone who punches you and you sue them for assault and battery, you could in fact claim that all the hospital bills that you might incur are the responsibility of the person who did in fact land the punch. Now, as we've talked about before, you can also sue for pain and suffering. There is going to be a way for a person to reclaim any kind of monetary damages for the mental aspect of this. Now, as we had kind of talked about before, putting a number, an amount of money on what the mental damages that come from this can be a little bit difficult, but yes, it can be awarded by the court. They can say that, yes, you sustained these damages mentally, so you are awarded a certain amount of money. Now, I do want to go ahead and talk about one that is fairly recent, what's called IIED, or intentional infliction of emotional distress. This really kind of came into existence or prominence probably about 30 years ago, give or take. What IIED is using words or actions that are meant to cause someone extreme anxiety and distress. Now, I always am very careful about this because you need to be certain that you understand something. These words or actions need to cause someone extreme anxiety or distress. Now, I emphasize this because even the court says that just these actions must be considered severe. Now, determining exactly what is severe can be a very difficult action because there's just so much gray area into what actions might be considered severe. The reason why the court says this is they say that, yes, the plaintiff must prove that there was extreme distress based on the actions of the defendant. Where, excuse me, where there's this dividing line of mere insults are not enough for a lawsuit. But again, there's just so much gray area that it's hard to really define what constitutes extreme anxiety and distress and what constitutes just insults. So I will tell you this, over the past roughly 20 years or so, judges and juries in this particular case are tending to actually rule more and more towards the plaintiff in that level of extreme anxiety and distress is starting to lessen and lessen. Now, you never really know. There might be some time where it starts to revert back, but at least now things are starting to move towards this, towards that line of potentially maybe in the future that insults will be enough for a lawsuit. But at least as of right now, that's kind of the dividing line where it has to prove extreme anxiety and distress. But it really just depends on the judge and the jury what that might entail. Now, I do want to go ahead and talk about number 4, which is false imprisonment. Now, I'm going to use an example here that is really kind of the example that's probably most prominent. For false imprisonment, what this is just someone confining someone else against their will. Now, if you have a situation where it's very criminal, then yes, you can use this for civil as well. But the one that I'm going to use as the example is that oftentimes what the court has in front of them is that false imprisonment can be considered if there's a shopkeeper that detains a potential shoplifter. Now, I'm always very careful about this because shopkeepers, an owner of a store, can detain a potential shoplifter. They can hold them, and oftentimes what like big box stores like Target or Home Depot or something like that, they actually have a specific area in the back of their store to hold potential shoplifters and wait for the police. Now, if you're going to be the shop owner that is holding someone against their will because you believe they've shoplifted, you can hold that person, but they must act reasonably. What that means is they can hold them in a particular room, but they can't hold them for an extended period of time. What the court has basically said is, as the shopkeeper, you can detain this person until the police show up. That's basically as far as the protections go. If you hold this person for hours upon hours, then you might have a civil lawsuit against you for false imprisonment. Now, again, it really does depend on kind of what the shopkeeper does, but as long as it's considered reasonable, they are well within their rights to detain a potential shoplifter. Now, the last one we're going to talk about for injury to person is defamation. Now, what defamation is this is where false statements are made about someone that harms that person's reputation. Now, again, there's really a lot of gray area within this. So what this is really suggesting is if you can prove that your reputation has been harmed by someone else making false statements about you, then yes, you can sue for monetary damages. But the problem is you have to prove the monetary damages that person's false statements cause. So I want to use kind of a classic example, and the courts kind of use this as well, where if there is a patient in a surgeon's office that yells out, "You're a butcher," to that surgeon, and they're in like the hospital hallway where other people can hear them, that surgeon could sue that person for making false statements. Because if you can prove that the people that were listening to this did not have a surgery performed by you because of what that person said, the person who yelled you are a butcher, then you can say that, yes, it cost me that amount of money, that my profession was harmed because of what that person said. If you can prove that, then you have a case. But there are going to be some difficulties with that. Now, defamation does in fact take two forms. If it's written defamation, it's called libel. So, like, for example, if a newspaper writes a story about you and you can prove that one, their statements are false, and two, it caused you financial hardship, then yes, you can sue. The other side of it is called slander. Now, slander is just spoken defamation, where, again, going back to the example, if that person yelled out to a surgeon, "You are a butcher," and it cost them financially, then you do have cause for a lawsuit. Now, I'm going to leave it right here, and we're going to build on something in class going forward with this.